Welcome, everybody, to Collier Bristow's US UK podcast, a series which looks at some of the more complex aspects of US UK tax and estate planning and tries to break it down into some more digestible chunks. If you're a regular listener to this podcast, please do leave a rating or a review or a comment on whatever platform you're listening on because it helps people find us afterwards. So thank you in advance. Today, we're going to turn the tables a little bit. Rather than thinking about Americans living in the UK, we're instead going to think about the Brit who goes abroad to the US. What are some of the US-focused estate planning tools that my guest might want to use when thinking about her own planning? And what are some of the UK pitfalls that I might want to make her aware of so that she knows what she can and can't do when someone may have some lingering connection to the UK? I'm joined today by Reshma Shah, a partner in the New York office of law firm Duane Morris. Reshma is a tax and estate planning attorney with a focus on cross-border and international clients, and I think she is therefore a perfect guest for today's podcast. Reshma, how are you?
I'm doing well. Thank you for having me, Aidan.
It's absolutely wonderful. It is slightly warm in this room today because we are recording this on a very, very warm summer day here in the UK. And when I say warm for the UK, I'm sure we mean absolutely tepid for you in New York, but such is the way of UK house building. One of the reasons why I was keen to discuss this topic is that we haven't had the time yet on this podcast series to focus really on what the US likes to do. And I've had a lot of guests sit here very patiently while I wax lyrical about UK estate planning. So I really want to turn everything on its head and think about what US attorneys like you, Reshma, like to do in the US. So let me pose you the hypothetical scenario where a client has walked through your door. You know nothing particularly about their circumstances, but you know that they are a high net worth individual. And let's just make them a US person for the time being. What are some of the most common estate planning tools, mechanisms, documents, ideas that you are using when you come to think about constructing an estate plan for a person like this?
Sure. So I would say about 98% of the time, most clients, we recommend that they have a pour-over will and what we call a revocable trust. And that's also sometimes referred to as living trusts. These are the key points of an estate plan. And so a pour-over will is a very simple document in which an executor and guardian is named, and the assets simply pour over into the revocable trust, the living trust. And the trust can either be funded during one's lifetime or it can be left unfunded and the will simply does the funding at the time of death. And so there are different ways to go about it. And depending on the circumstances and the facts surrounding the actual individual, we often recommend, if funding is possible, that it be done during their lifetime. Now, one of the key reasons we recommend the use of the revocable trust is because there is ease of administration in the long term, where the beneficiaries have access to the assets and there's minimal court involvement needed during the duration of the continuing trust. So to the extent that funding of the trust is possible, we do recommend it be done. And I hope no one from the New York probate department is listening because the court process is quite cumbersome. The courts are very backlogged. It's not a fun process to go through. It's actually been terrible during the last 3 years, especially with COVID, because of the closures, the delays in getting responses from the court and just getting documents issued by the court. So all of it's been a sort of a terrifying process.
For the benefit of anyone in the UK who's listening, and also for the benefit of, a hypothetical podcast host who's always wanted to put a few numbers to this, I've always known that the US process, the probate process, is one that is respected and feared in equal measure, shall we say, by Americans and their practitioners. Is it possible to put any kind of values or figures to quite, even in the most, so let's take a generic, straightforward process, what sort of timescales a person might typically expect that process to take when the US courts get involved, and what kind of either, let's just say just the administration fees, not even accounting, accountancy or legal fees, etc., but just kind of what kind of administration costs and time is someone looking at if they do have to go through that process in New York?
So we're talking about thousands and thousands of dollars and up to about a year and a half of the court involvement.
Probate fee, is that administration fee, is that ratcheted to the value of the estate, or is that on a fairly fixed basis?
The fee itself is on a fixed basis. I think it's about, in New York, it goes up to about $12.50 $1,250.
Mhm.
And so that the fee itself is not the expensive part of it. It's the legal expense of hiring attorneys, getting the probate paperwork, submitted, and then the back and forth with the court every time they ask for additional documents, and you're trying to figure out, why are you asking me for this unnecessary piece of paper?
Because I'm not trying to put any attorney, let alone you, Reshma, out of a job. Would it be conceivable, is it at all possible for someone to go through that process without taking legal representation? Because in the UK, there is no requirement, no need to use a lawyer. People do, and if your estates are complicated, particularly where tax is due, significant tax is due, consulting a lawyer is always recommended, he says, as a lawyer. In the US, is that effectively baked into that process because you're dealing with the courts and it's almost a non-starter to try and do it without legal representation?
You can absolutely try. There's nothing requiring you to have legal representation, although I can only imagine how difficult it is for someone to navigate the system if they do not have the experience or knowledge of what they're getting into.
I think we can take it as read that there's a reason why, when I deal with US attorneys, every single one of them speaks with one voice as saying, do not go through the process, do not go through the process, do not go through the process. If I've learned one thing, it's do not go through the process. So that is why you set up a living trust with the poor of a will. And am I right that, because you mentioned funding versus non-funding, the whole reason behind the living trust's existence is that you sort of are nominally holding the wealth outside of an individual's estate during their lifetime, so that you don't need to apply for a grant of probate or your equivalent document to have the title to the assets transferred. Why would one want to have the living trust but only have it funded beyond a notional $100, let's say? Why would you only want to wait for the assets to pour over at death, but you'd leave the sort of asset, the trust on the shelf funded during your lifetime? What's the New York benefit to sort of the funded versus non-funded? Because in the UK, and we'll come on to that possibly later, there could be a significant difference. But for US purposes, why might you choose one or the other?
So once the trust is created, you have the option of funding it. Now, some individuals may not want to take the steps of funding it because it requires reaching out to the financial institutions where their accounts are held, and it requires some additional follow-up on their part to get the actual accounts and assets into the trust. Now, it's not required that they do it because the benefits will still be reaped when they pass away, and the assets will flow into the trust upon their death because of the pour over will providing for such. Now, the benefit of having done so during one's lifetime is that you're minimizing the work required for the executor. Now, if the assets are already in the trust, that's less that the executor needs to do. And if everything is in the trust already, then the executor has nothing to do. There's no need to probate the will at all. The will really has no purpose other than potentially needing a guardian appointed if you have a minor child. In the event that you cannot fund the trust, or you choose not to, or don't get around to it, now there's still benefits of having that trust in existence, because the continuing trusts that are created within that living trust, so trust for a spouse, trust for descendants, trust for other beneficiaries, those continuing trusts will not have continued court involvement during the duration of that trust's lifetime, because that trust is created within a living trust that can function on its own, with the trustees taking action without needing to go back to the court for permission, or needing to go back to the court whenever there's a change of trustee or other acts involved within the administration of the trust itself.
I presume you can't speak to other states within the US because you're a New York attorney. To the best of your knowledge, is that inter vivos versus on death distinction between continuing trusts, is that something that's unique to New York? That's a tongue twister. Or is that something that is common across other states, that the sheer fact of the trust being created during one's lifetime means that the ongoing regulation by the courts is more limited? Do you know if that's the case in other states?
Yes, that is the case. Now, there are different rules that apply to community property states with respect to your ability to transfer and things like that. But generally, that does apply across other states.
We might come back to that, because when you've got UK individuals, that could make a considerable difference. Am I also right that this is all, he's making hand gestures in one direction, this is all focused on avoiding probate? So where there are reasons why an asset might not have to go through probate, the need for the living trust is perhaps less necessary. Jointly held assets or accounts where you've got a transfer on death arrangement, a beneficiary designation, in theory, you wouldn't need the living trust to avoid probate. sort of is my part A question. My part B question is, that being said, given it's just easier just to write the poor will to say everything else that's left, it's easier just to dump the whole lot into the living trust anyway, which is why you don't go through and nitpick all of your assets to say, well, this one will go into the trust and that one won't go into the trust. Am I right that there are other ways to avoid probate absent a living trust that you use in the US?
That is correct. So you can avoid probate with respect to assets that are jointly held, which will pass by operation of law automatically to the joint owner on that property. And you can also have either a transfer on death or something we call a beneficiary designation. That is permitted on certain assets such as retirement accounts, life insurance policies, or even some bank accounts that allow you to put transfer on death, TOD forms on the account, which basically allows you to designate who the primary and secondary beneficiaries will be for that asset upon your death. So that designation will dictate how that asset passes automatically upon the death of the owner. There is no need to go through the court for transfer of that asset because that designation overrides any other estate planning document.
And am I right that that would be a binding designation? It's not a sort of a pension nomination of wishes where you're requesting to some pension trustees that this is who you'd like money to go to, which is a significant difference in the UK where you're dealing with assets inside the scope of inheritance tax. A beneficiary designation, I'm assuming, is a binding statement you make to the particular institution that says, on my death, you must give these assets to that person. Am I right about that distinction?
Correct. And what's key about that is that you have that designation properly submitted to the institution that holds the assets. You can't just keep it to yourself thinking, all right, these are my wishes. Let me put it in my drawer over here and so someone will find it.
Staggeringly, some beneficiary might come forward 10 years later and find a slip of paper that says, I'll tell you what, that account should have come to me. And how come you bank didn't give it to me at the time, even though you weren't to know it? I think that is asked and answered about why living trusts are useful. And as I said, we have done an episode already specifically looking at why we in the UK bulk slightly when it comes to living trust. And we'll come back to perhaps some of the consequences of a living trust in the context of the US estate plan when we think about how we throw the UK individual hand grenade into Reshma's otherwise beautiful estate planning in the second half of this series. If I can sort of push you sort of towards the other side of the estate planning discussion, which I usually have with clients, sort of away from will planning and on towards the lifetime planning, you as an American practitioner will be undoubtedly, very used to putting trusts in place for your clients. You're probably the only jurisdiction collectively across all the states that like trusts more than the UK. What are some of the main reasons why a client in your circumstances that comes to see you might want to put in place the sort of trust now during their lifetime rather than sort of waiting until death for the trusts to sort of activate?
So when we're talking about revocable trusts, the ease of putting it in during your lifetime, really the benefits are administrative. Mm-hmm. And so there are no tax benefits to funding your living trust during your lifetime because the assets are still taxable to you. You still have the same control. They're still reported in the same way to the IRS. It's merely just administrative. So if the owner of the living trust, the owner of those assets, let's say, becomes incapacitated, then the successor trustee named in that living trust has immediate access to those assets and can administer them and make distributions and have access immediately without, let's say, turning to a power of attorney to need access to those individual assets. Now, even upon death, the assets are immediately accessible to the successor trustee and the beneficiaries of the decedent without going through any sort of court process. And so you have the ease of administration of just having your heirs have the access to the assets immediately, whether it comes to paying for funeral expenses or other expenses that arise quickly after death. They're not left stranded or at the mercy of the court waiting for access to those assets. Now, there are different types of trusts that can be created during lifetime, aside from living trusts, where you actually give up control and you make gifts into a trust in which you are sort of segregating those assets and saying, these are no longer part of my estate. And those are different tax opportunities that are available to U.S. individuals who want to take advantage of their estate tax exemption and gift tax exemption during their lifetime. And we can get into that if you'd like to talk about those type of inter-rivals trusts.
That would be the distinction to my UK lawyer's brain. That would be the distinction between a grantor trust and a non-grantor trust for your purposes. Am I right?
Yeah. So for our purposes, you can make a gift and make use of your gift tax exemption. And right now the exemption is fairly high. It's the highest it's ever been at $12.9 million per person in the US. So high net worth individuals who have the ability to give away these funds, it's a unique opportunity to do so. And if you're comfortable with giving away assets and you feel that you have enough to survive on outside of what you've given away, it's definitely a tax opportunity that's available, I would say, for a limited amount of time, because we don't know what's going to happen come 2026 when this exemption is set to expire.
So, you have this potential sort of use it or lose it scenario, don't you, in the US at the moment, where your exemption is currently, I mean, if inflation continues the way it is, it might even be sort of 14 million by the time it sunsets, but it's going to go down to 5.5, 6 or something. And you've kind of got a spare $5.5, $6 million of exemption that you're not going to have from 2026. And so if you were thinking about maximizing the amount of money you could put into trust, here is your sort of one-off opportunity for a couple to put, gosh, I don't know, $25 million into a trust without paying tax, where after 1 January 26, the opportunity is gone, subject to the, I guess, 2024 election.
Precisely. So we have this unique opportunity where you can give away assets, and there are certain jurisdictions in which you can actually have the security of being added back in as a beneficiary if there is a circumstance where you need to be, let's say, in an asset protection jurisdiction such as Delaware or South Dakota or Nevada, where you can set up a trust, let's say for the benefit of your spouse or for your children. You've gifted away these assets, you've utilized your exemption, and these assets are now appreciating outside of your taxable estate. And so you want to give away assets that are going to grow, assets that you're not going to necessarily need access to. And essentially, you've protected the growth of those assets from being includable in your taxable estate, because in a situation where you know you're going to have a taxable estate, you are protecting these assets from being subject to 40% estate tax. And so it's a unique scenario where you can sort of segregate these assets now and then still have the security of, God forbid something happens and you run out of all your other money, you can still tack onto that and make use of those funds at some later point if you absolutely need to.
I was intrigued with what you said a few minutes ago, which was where I was intending to go anyway. So you signposted it beautifully yourself. You said about possibly setting up a trust in a different jurisdiction. I, again, in my sort of layman's understanding of the US, know that there are certain jurisdictions that are particularly favorable to trusts and to companies. And there are sort of jurisdictions like South Dakota and Delaware that are, you probably have 1,000 trusts for every person that lives there. Why might someone want to set up a trust in Delaware, let's say, or an LLC or anything else for that matter? What is it about going to Delaware that you don't get from being in a jurisdiction like New York?
So New York does not allow for self-settled trusts. And so in New York, you cannot set up a trust where you've gifted away money where you are still a beneficiary of that trust. Certain jurisdictions like Delaware have very good asset protection rules where you can set up a trust where you would have the flexibility in the worst case scenario where you can be added in as a beneficiary, or you can be a beneficiary from the beginning of the trust. And so there are certain benefits of setting up trusts in those types of asset protection jurisdictions because the court rulings are very favorable and they're very protective of those types of situations.
And presumably, I mean, that's just on the trust side. I mean, on the tax side, I mean, I'm going to presume Delaware has no state income tax.
That's correct.
So it's also tax efficient as well as robust from a trust perspective to set a trust up in one of those jurisdictions.
That's right.
I think the answer is clear. There is excellent, understandable, robust planning that any American would want to put in place where they are fortunate enough to be in a position where they have wealth they no longer need. As you say, they can afford to, and if they can afford to, it being the sort of the operative phrase, give it away, then there are certainly things they can do. I raise the spectre again of the hand grenade I'm going to throw into your planning after we come back for the UK person. One other thing on the lifetime planning that I want to stop and reflect on so that we might reflect, sort of compare it to the UK later, is moving from, as one of my colleagues likes to say, the cheery topic of death to the even cheerier topic of incapacity, do you in the US like to include a power of attorney discussion alongside sort of wills and estate planning, sort of rounding out that sort of pack of documents an individual has to sign? So what happens in the US if your individual loses capacity, you'll have sort of documents you want to put in place to have guarded against that?
Absolutely. So whenever we prepare an estate plan for an individual, not only do we include the pour-over will and the revocable living trust, but we also include what we call ancillary documents. And these ancillary documents typically consist of healthcare documents and a power of attorney. And sometimes if they're interested, also something called a disposition of remains, where they go through the process of how they want to be treated, if they want to be cremated, if they want a funeral, et cetera, and who they want to appoint for those various decisions. So with respect to the healthcare document, New York allows you to appoint one individual at a time to make medical decisions for you if you're unable to make them yourself. And, oftentimes we have individuals that say, I want to name both of my kids. Let me put them together. Well, we can't exactly put them together because we need one individual, but we can include language that allows them to consult with each other when making decisions. So when you want both kids to have sort of equal bearings in making those decisions. And then also when it comes to a power of attorney, we do recommend that you appoint individuals to make financial decisions for you if you're unable to do so. And so you can have a durable power of attorney that's effective immediately when you sign it, or you can have a springing power, which is effective only upon incapacity.
Durable power, I'm very familiar with. I don't think I'd ever heard of a springing power. So yeah, it makes sense to do the comparison. Now, the UK has similar process, but rather than having different terms for the medical and for the finance, we just refer to all of them as lasting powers of attorney. We don't also differentiate between durable and springing. For a finance power, you can also, like in the US, state that you want it to take effect the moment it's registered, or you can have it specified so that it only takes effect on incapacity. Healthcare lasting power of attorney, which is our version of a medical directive or a healthcare proxy, can only take effect on incapacity. But we are content with you appointing multiple attorneys. You can have up to 4 attorneys and you can have up to 4 replacement attorneys, and you can specify whether you want them to act jointly, i.e. they all have to make the decisions together, which is not usually our recommendation because it's very clunky, because if one person's not there, then the others can't decide, or you can have them appointed jointly and severally. So any individual can make that decision on behalf of the group. You, of course, then need to make sure that you trust each of the individuals to act in your best interests. There are significant overarching sort of mental capacity rules, legislation, etc., that sort of says, you must do so anyway, but you have to really, really implicitly trust the person that you are appointing as your attorney, I guess. I was also interested, just because it's an amusing aside, and I say amusing, slightly morbidly amusing aside, because at the end of this first half,
this whole topic is pretty morbid, right?
Yeah, it is. I know. You mentioned the what was the name of the document you said about what happens to your remains after death?
Oh, disposition of remains.
And that's just something that gets lodged with the documents and someone brings it out and says this person did or didn't want to be cremated. That is presumably something you need to have to hand relatively quickly, because if someone says, I want this particular wish for my funeral, or don't do this to me because, the common example is I'm Catholic, I don't want to be cremated. That's something that you have to be able to present quite quickly to the beneficiaries, lest you say, terribly sorry, discovered this later, didn't realize that, great aunt Josephine didn't want this. Here's your urn, I'm terribly sorry.
Yeah, so that's a document that we keep separate and apart from the will. And these are instructions we do not recommend you put in your will, because oftentimes the will is not located long after you've been buried or cremated, whatever the case may be. So we want to make clear that these ancillary documents are separate and apart and readily available.
The most novel one of those statements I ever received was someone who wanted 2 independent medical practitioners to confirm he really was dead, rather than just the coroner, because he was concerned that he was going to be buried alive. And so he needed 3 individual independent people to specify that he was definitely dead before he went under the ground. I don't know if that person's still alive. It was about 10 years ago. They probably are. If they've worked out who they are, you are quite an amusing story. I'm going to bring this podcast episode to a close, or at least the first half of this podcast episode to a close. It's not the end of the story. Reshma will be back, so don't fear. When we come back, Reshma and I are going to reflect on her estate planning and how I'm going to make it much more complicated if we chuck a UK person into the mix. My thanks go to Reshma for now. Thank you to you, the listener, and we will see you again next time. Stay tuned.
Thanks very much.